There are two types of jurisdiction. There's in personam jurisdiction, and then there's in rem jurisdiction. So with in personam jurisdiction, this is the court's um, authority to exercise jurisdiction over the parties to a controversy. So what that means is the court has to have the ability to exercise its powers over the parties to the litigation. So in the previous slide, we looked at subject matter jurisdiction, and with subject matter jurisdiction, there are or the courts are limited based on certain types of causes of action that they can hear. When we get to in personam jurisdiction, that relates to the question we ask the question: does the court have the power? Does the court have the authority or the power to exercise jurisdiction over the parties to that matter? So a state court has in personam jurisdiction when a party is present in the state when served with a lawsuit, resides in the state, or consents to jurisdiction of the state. So there's a whole class in law school that covers this. You get into the question of like, let's say you operate a business and you sell goods to somebody in another state. The question is and then that individual wants to sue you in that state. Then the question becomes: does that court have the authority to exercise? Does the court have the power to exercise jurisdiction over you in that state? Right. So that's the first type of jurisdiction, in personam jurisdiction. The second is in rem jurisdiction, and this refers to a court's power or jurisdiction over a particular piece of property. So a state has in rem jurisdiction in the state in which the property is located. So if, in the example I had previously given, if you have a probate that is opened in Texas and there's a piece of land in Colorado that is owned by that estate or that is subject to that estate, then the Texas court does not have jurisdiction over that property in Colorado because that property is located in Colorado, and the court's jurisdiction in Texas, the Texas court's jurisdiction, does not extend into Colorado. So in that case, you would open the probate in Texas, and then you would open an ancillary probate in Colorado to take care of the property issue, and then bring that back under the estate administration in Texas. So the state court system, most real property laws are created by the state, and every state operates a court system to interpret and apply state laws. So while many real estate disputes are resolved through ADR, alternative dispute resolution, most disputes are resolved through the state court system. Primary purpose of these courts is to settle disputes through a legal process following both federal and state laws, if they're applicable. And then courts make findings of facts and apply the laws to reach a binding decision. So then I've got the website to the Texas court system, which provides an overview, and we're going to go ahead and go there and take a look at this. So this is the Texas courts page, and you can find this by Googling Texas courts or by going to the website you just saw in the slide. I'm going to go ahead and click on courts and then about Texas courts, and then I'm going to look at the court structure. And so this is as of September 1st of 2019, and we have two Supreme Courts, or the highest courts in the state of Texas. We have the Texas Supreme Court, which handles civil matters, and then also juvenile cases. Juvenile cases are quasi-criminal in nature, in that they apply the Texas Criminal Code, the Texas Code of Criminal Procedure, and the Texas Family Code, which is civil. The first two are criminal, and then the Texas Family Code, and then the Texas Rules of Evidence, which are civil, apply to juvenile cases. And so any appeals on juvenile matters go up to the Texas Supreme Court. And then for criminal matters, we have the Texas Court of Criminal Appeals. Then we have the intermediate courts. So we have 14 in Texas with 80 justices. And then these courts of appeals are divided geographically throughout the state of Texas. And then we have 477 district courts. And this is the trial court level. And you can see here that district courts in Texas have original jurisdiction in civil actions over $200, title to land, and then contested elections. Original jurisdiction in felony criminal matters. The district courts handle juvenile matters. And then we have 13 district courts are designated criminal district courts. Others are given preference in terms of what type of specialized cases they may hear. And then we have 380 districts containing one county, and 97 districts containing more than one county. So what that means is you could have one court, for example, that let's say one county has 3 district courts in that county, and one of those courts hears matters in that county, and then 2 other counties that are adjacent to that county, and then one of the other district courts handles matters in that county, and then 2 other cases in another county or 2 other counties that are also adjacent but not the same as the first district court, the counties handled by the first district court. So that's where we get into multi-district courts. And then there's other district courts that just hear cases within that county itself. Now, when we talked about subject matter jurisdiction, going back to subject matter jurisdiction, district courts can hear juvenile matters. District courts hear felony cases. When we get to the county courts hear misdemeanor cases, right? So that's where we get into subject matter jurisdiction. And then also original jurisdiction in civil actions over $200. So if you had a small claims that was, $100, you couldn't file that in district court. You'd have to go to either, one of the other courts where that option is available, and more likely than not, that would be in at the JP level. So this was part of this covers the subject matter jurisdiction, and then district courts have the power of in personam jurisdiction over individuals in the state of Texas, and then if you have a resident that's outside the state of Texas but travels to the state of Texas and is served in the state of Texas, then the court then has jurisdiction over that individual. Or if that individual from out of state were to file an answer in the court, then they have subjected themselves to the jurisdiction of that court. We have, at the county court level, we have 524 courts, and each county has at least one county court, and that's referred to as a constitutional county court. Okay, so we have 254 counties in Texas, and each county has one county court. Original jurisdiction in civil actions are between $200 and $10,000. The constitutional county court hears probate and guardianship matters, or can, and they're not the only one. So that case could get assigned to a district court. That case could get assigned to the constitutional county court, could get assigned to the statutory county court. We'll talk about in a minute. Exclusive jurisdiction over misdemeanors with fines greater than $500 or jail sentence, juvenile matters, and then appeals de novo from lower courts, such as the municipal court or the JP court. And so what that de novo means is we start over again, basically. So if you had a JP matter, you appealed it to the county court, then you start that trial over at the county court level. We have 252 statutory county courts at law. We call those county courts at law. And these courts hear all civil, criminal, and original appellate actions prescribed by law for constitutional county courts over here, right here. And then, in addition, jurisdiction over civil matters between $200 and $200,000. And then some courts may have a higher jurisdiction amount. And so that's when that court is created. So by law, these courts are already created. These courts are created if there's a need. So, for example, the county grows and says, we need an additional 1 or more county courts, and we need 1 or more district courts. And so then there's a process of doing that by going to the legislature and having that court approved by the legislature. And so that's where this is a constitutional county court. These are statutory county courts. These are created by the Texas Constitution. These are created by the legislature, and that's why they're called a statutory county court. And then when they're created, they could be a court, what's called a court of general jurisdiction, which means they can hear all matters. Now, not all matters, but they can hear they're not limited. They're not confined. So they could hear all civil, all criminal, and all original appellate actions. So that could be civil cases between $200,000 and $200,000. That could be misdemeanor cases. That could be juvenile cases. That could be appeals from the lower courts. So we call that a court. It's a general statutory county court, and then we also have courts that are, and this applies to district courts as well, that are created specifically for a purpose. So let's say a county is growing, and then that county needs additional assistance with criminal matters and with family law matters. So the county goes to the legislature and says, we need an additional statutory county court specifically for these two types of matters because these cases have just exploded exponentially in this county, and we need more assistance to do that. The legislature will approve the creation of that court with those limitations. So that court then could only hear, for example, maybe certain types of criminal matters and then family law matters. And so then whenever a case is filed, either a civil matter or whenever a criminal matter is originated, then there's a process in that county where those cases get assigned to the courts. And so then when the next family law matter comes up, not all of them get assigned to that court. It's just those that's all that court can hear. And so as part of that rotation of those cases being assigned, then only family and criminal law matters would get assigned to that court. And then, when we look at these caps here, so we have a $10,000 cap here on civil actions. So if you have a lawsuit for example, you wouldn't file a medical malpractice lawsuit in a constitutional county court because you are capped at $10,000 in terms of your damages. In theory, you could file a case like that there, but if you were to obtain a judgment for greater than $10,000, you're capped at $10,000. And then same thing here with the statutory county court, where you're capped at $200,000. Okay. Then finally we have statutory probate courts. So we have 18 courts in 10 counties, and generally you're going to find these statutory probate courts in your larger in your counties that have a larger population. So Bexar County has 2 statutory probate courts, probate court number 1, probate court number 2, and that's all they hear are probate matter or cases related to probate and ancillary cases related to probate and guardianship. And so if you were to file a probate in Bexar County, for example, you would file it with the statutory probate county court at law. Then we go down to the county level and then the municipal level here with the justice courts. And this is also what used to be referred to as small claims courts, but now there was 2 different types of courts. Back in the day, there was the small claims court, and then there's the justice court or the JP court. And they were both under the justice courts. It depended upon how you filed that action in that court, and then there were certain things that came into play based on the type of or based on how you filed that case. In terms of if you filed in a small claims court, then the rules of evidence were relaxed. The process for appeal is different than if you filed it as a justice court suit. If you filed it as a justice court suit, rules of evidence are in play. It would be comparable to filing it in the county court or in the district court. But we had created the small claims specifically for individuals that were representing themselves on smaller matters. Years ago, the cap for justice suits was $5,000, and that has been raised to $10,000. And I think that's because over time you have a breach of contract claim, and that breach of contract is $8,000. And it used to be that it was $10,000. I mean, it was $5,000 all inclusive of everything. The damages, the attorney's fees, prejudgment interest, post-judgment interest, everything. And so now that cap has been raised to $10,000, which is not all inclusive of everything. So it's $10,000 for the damages, and then you've got attorney's fees in addition to that. So is to provide a little bit more flexibility, because otherwise you had individuals that were being forced to file their litigation in the county court, and the county courts are, were getting overloaded with all of the cases they're having to handle. So, if you've got a case that where the damages were between $5,000 and $10,000, then that would have had to have been filed in county court or in district court. And so now by bumping that up, that gives a little bit more flexibility of being able to file that matter in justice court. And the benefit of that is that whereas filing in county court or district court may take longer to get to trial, just because of the docket in each of those courts, that generally you can get to trial in a justice court much more efficiently. And so there's a benefit. So there's a process in terms of trying to determine where you're going to file a lawsuit and why. Justice court, and so now there are 4 types of cases under justice courts, and one of those is small claims. But there were some other cases, there were some other causes of action that were specifically created for certain types of actions. So you had small claims, and you had debt collection, you had landlord-tenant, and then I forgot what the 4th one is right off. And then so those are kind of classified based on, so you file the lawsuit under one of those 4 headings in the justice court. And then we also have criminal misdemeanors that are punishable by fine only, so no confinement. So and then justice courts can also perform magistrate functions. And so what that means is you have magistrate judges that are available to somebody gets arrested, then they have to be magistrated within a certain time frame on a criminal matter, and so justice courts can provide that function. And then with municipal courts, so these are on the criminal side. If you get a speeding ticket out in the county, you're going to end up having to handle that through the justice court. If you get a speeding ticket in the city, you would end up handling that in the municipal court. And so municipal courts handle criminal misdemeanors that are punishable by fine only, so like a speeding ticket, or if you have a code violation, you don't mow your yard and the grass gets too high and code enforcement issues a ticket or a citation. If you leave your car up on blocks in the yard and the code enforcement sends out a letter and says you need to remedy this issue and you don't, and they issue a citation, you're handling that in the municipal court. So the municipal courts have exclusive original jurisdiction over municipal ordinance criminal cases. And then they are limited to civil jurisdiction. And then they also provide magistrate functions as well. One other thing I wanted to show you in relation to the courts are the courts of appeals. And then there are 14 courts of appeals in the state of Texas, and Houston has 2. Houston has the 1st and the 14th. But there are specific counties that are assigned to each of those courts of appeals. So the first court of appeals includes this list of counties, and the fourth court of or the 14th court of appeals covers these counties. And then we got the second court of appeals. Let's see here, Austin and the counties around Austin are out of the third court of appeals. San Antonio covers the fourth court of appeals covers San Antonio or Bexar County and the surrounding counties. And then, we've got others throughout Texas. You can see how they're kind of broken down geographically. So that's the list of the courts of appeals in Texas and the associated counties that are, or the counties that are associated with each of those courts of appeals. On the federal court system, so Article 3 of the U.S. Constitution established the federal court system. The federal courts have the power or jurisdiction to decide those cases that Congress authorizes them to decide. So there again, when that court is created, then if Congress limits the authority or specifies the authority of that court, then those are the cases that court can hear. The primary trial courts of the federal court system are the U.S. district courts. So, like in Texas, we have the municipal courts and the JP courts. Then we go to the constitutional county courts and the statutory county courts. Then we go to the district courts, and then the appellate courts, and then the Texas Supreme Court, and then the Court of Criminal Appeals. On the federal level, we have the U.S. district courts. The decisions of the district courts may be appealed to the U.S. Court of Appeals, and then from there they would go to the U.S. Supreme Court. The decisions of the federal courts of appeals serve as the final decision in most federal court litigation and create binding legal precedent for all lower federal courts within that circuit. So that's where we have the stare decisis coming into play with appellate courts in the federal system, just like we have in the state system. Lower federal courts must follow the binding precedent under the stare decisis doctrine in deciding future similar cases. That's what I just said. The common means for a federal court to hear a real estate matter is premised upon one of a couple of types of jurisdiction. So that's where we look at the federal question jurisdiction. So the first is known as federal question jurisdiction, in which the federal courts have the authority to decide a dispute arising substantially under federal law. So does it arise under the U.S. Constitution, any of the treaties, federal statutes, or federal regulations? So that's where we're getting into, you kind of call that subject matter jurisdiction, so it relates to federal laws. In addition, federal courts have exclusive jurisdiction to hear matters relating to real estate involving federal crimes, antitrust, bankruptcy, lawsuits brought against the United States, or other cases specified by a federal statute. So that's where we see some elements related to real estate. To have exclusive jurisdiction means the federal court is the sole forum for determining these types of cases. So when we use the word exclusive jurisdiction, that means that only that court can hear that kind of a case. So you wouldn't file an antitrust violation, a federal antitrust violation, in state district court, or a bankruptcy matter at the state level. So, for example, if a homeowner filed bankruptcy to forestall a mortgage foreclosure, the matter would be heard in federal court, and that would be specifically in a bankruptcy court. Diversity of citizenship comes into play on the federal level. So, for a federal court to hear a case based on diversity of citizenship, two elements are required. So, this is where we have individuals that are not in the same jurisdiction. They don't live in the same jurisdiction. So let's say you have two individuals on the federal level that live in different states, and so there's one individual wants to file a lawsuit in federal court. So this is where we look at diversity of citizenship to determine if that individual can file in district court. And so here, what we look at here, there must be two elements. The two elements must be met. One, the amount of controversy must exceed $75,000. So we don't want somebody filing just a $3,000 breach of contract suit in federal court. So it has to have some substance to it. And then two, all the parties to the litigation must be diverse in their citizenship. And so the key though is that if you get you could have one individual, you could have some individuals in Texas and one individual that lives in New York, and for whatever reason you want to litigate that matter in federal district court in New York, is if you can meet the diversity of citizenship test in that case and get that individual in New York under that litigation, then anybody else associated with that litigation then is subject to the jurisdiction of that court. Generally, the last qualification means that the parties, both plaintiffs and defendants in a dispute, are citizens of different states, or a citizen of a state and a citizen of a foreign country. So, for example, Dwayne, a resident of Illinois, is driving on vacation and is rear-ended by Marcus, a resident of Ohio. The accident occurs in Indiana. As a result of this accident, Dwayne's car was severely damaged, and Dwayne suffered extensive personal injuries. In total, the cost to repair Dwayne's car and pay his medical bills amounted to nearly $100,000. If Dwayne sues Marcus for damages, he could do so in federal court under diversity of citizenship jurisdiction, as Dwayne and Marcus are residents of different states, and the amount in controversy exceeds $75,000. So here we look at the summary of federal court jurisdiction. So the basis of jurisdiction, we look at the source of law for the dispute, and it must be a federal question related to the Constitution or federal statute or treaty, or you have diversity of citizenship. The minimum amount in dispute, if it's strictly a federal question, it's none. If you're applying diversity of citizenship, then the amount in controversy must exceed $75,000. And then if it's a federal question issue, must the parties of the citizens be of different states? And the answer is no if it's just a federal question, and then yes if you're applying diversity of citizenship. The U.S. Supreme Court, which is the highest court in the United States, accepts approximately 80 cases each year out of the approximately 7,000 to 8,000 cases filed for review in the U.S. Supreme Court. So the U.S. Supreme Court does not hear that many cases. What they do is they will pick cases that they think are relevant. There's a system, but that are relevant in relation to the subject matter, in relation to a change in society, based on the law, whether the issue will maybe create new law. So there's a number of factors that come into play in determining what cases the U.S. Supreme Court accepts. So in order for the Supreme Court to even look at the case, an individual wanting to appeal from one of the circuit courts, one of the appellate courts on the federal level, would file a petition for writ of cert or writ of certiorari. We shorten that just to writ of cert. And so which is basically a request for the court to hear the appeal. So we do that not only with the U.S. Supreme Court, but we also do that with the Texas Supreme Court as well. If you want the Texas Supreme Court to hear an appeal, you would also file a writ of cert with the Texas Supreme Court. So on the federal level, though, with the U.S. Supreme Court, a minimum of 4 of the 9 justices must agree to review the case. And then if this occurs, the court issues a writ of cert and then hears the case. If a writ of cert is denied by the Supreme Court, the decision of the lower court remains unaffected. So there are some ways sometimes where the court, one of the things you look at is that throughout the U.S., you may have, because the U.S. is diverse, in geography and in terms of demographics, you may have a different application of the law throughout the United States. So if the Fifth Circuit, which covers the state of Texas, has issued a ruling, and that differs from, let's say, the Ninth Circuit. So there are 2 applications of the same law throughout the United States. So you may have one of the individuals that, in those cases, that then applies or files a petition for writ of cert with the U.S. Supreme Court to one, to hear that case, and then 2, sometimes an attempt to get the Supreme Court to render a decision to say, well, what is the law in the United States? Because right now, in the example I just gave you, it's 2 different circuits. There have been times where you have a different application in more than 2 circuits. And sometimes it's not that it's vastly different. It's just you have this different application of the law, or how the courts applied the law in those cases. And so then you want the Supreme Court to say, we need a final answer in terms of what is the law related to this issue in the United States. And so sometimes the court will hear that. There are other times where the court can, if the court denies the petition, then what that does is it leaves the question open in terms of what is the law. So you still have the imbalance of the application of the law throughout the United States. There's another way that the court can deny hearing that case, but can basically say, yes, we agree with the opinion. And so then that's not necessarily the law on its face, but that's where individuals then look to that to go, well, look, the court basically said we're not going to hear this case, but we agree with the decision that this appellate court made. And so so there are some ways that when you're then trying to use that case as primary authority, that then it's valid. This is the breakdown of the courts of appeals throughout the United States. As I said, Texas is governed by the Fifth Court of Appeals, and then you can see the overlay of the other courts. And then we call these circuits. So the Fifth Circuit, First, Second, Third, Fourth, Fifth, all the way through the 11th Circuit. And we also have the D.C. Circuit. Venue is extremely important. So venue is a different concept from jurisdiction. It's the place where a particular case should be filed or administered by a court. So this is something I want you to, if you get nothing else out of this this first the review of this first chapter, I want to make sure that you remember venue. Okay. Every state has rules that determine the proper venue for different types of lawsuits. It might be the county where the dispute arose, where a defendant resides, or where the property in a dispute is located. So a plaintiff may sue in any of these places permitted by state venue law. So if we go to like the Texas Civil Practice and Remedies Code, and so I did not get to show you this earlier, but let's go take a look at this. So I'm going to go to capital.texas.gov. So capital.texas.gov. That takes me to the Texas Legislature site. And I'm going to go to statutes. And I'm going to click on Texas statutes. And I'm going to go to the Civil Practice and Remedies Code. So this is a list of all the, almost all the statutes in Texas. And then I want to look at venue right here, Chapter 15. And so here we go. So we can see venue general rule. Okay, except as otherwise provided by this subchapter or subchapter B or C, all lawsuits shall be brought, number one, in the county in which all or a substantial part of the events or omissions giving rise to the claim occurred. So that's where if there's a breach of contract claim, where did a substantial part of the events giving rise to that claim occurred, so it'd be in that county. So here we're looking. So we look at jurisdiction. So the question is, does a Texas court have jurisdiction over the parties, or does the Texas court have jurisdiction over the property? Okay, so that's over the state as a whole. Now we're breaking it down in terms of which county would you end up in with litigation based on these based on this rule. So in a county in which all a substantial part of the events or omissions giving rise to the claim occurred, in the county of defendant's residence at the time of the cause of action, at the time of the cause of action accrued, if defendant is a natural person, so that means an individual, that means be like you. In the county of the defendant's principal office in this state, if the defendant is not a natural person, so that would be a corporation, LLC, limited liability company, general partnership, limited partnership. So in the county of the defendant's principal office, and then if subdivisions 1, 2, and 3 do not apply, in the county in which the plaintiff resided at the time of the accrual of the cause of action. So this is where the lawsuit is actually filed. So if we determine that the Texas courts have jurisdiction over the parties, then we're trying to determine where are we going to file that lawsuit. And so then the question is, where do you want to file the lawsuit? Where would you want the lawsuit filed? And so this covers the rules, or these are the rules for where that lawsuit should be filed. Then we also have mandatory venue. So, for example, land, actions for recovery of real property or an estate or interest in real property, for partition of real property, to remove an encumbrance, yada, 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 will be brought in the county in which all or part of the property is located. So that's going to limit the venue to that county. Landlord-tenant matters, except as provided by another statute prescribing a mandatory venue. A suit between a landlord and tenant arising under a lease shall be brought in the county in which all or part of the real property is located. So that's where we get into certain, mandatory venue. But one thing you can do is you can contractually agree as to what the venue will be in your contract. And so I'll give you an example. I had a student years ago, undergrad student, and this was when I was teaching business law, and I covered this same topic, venue. And I said, you need to make sure that you specify the venue in your, or at least you need to address it. You need to at least think about it. What what the venue will be or where the venue will be in the event of litigation. And so so he graduated. He went to work for a real estate developer, and that real estate developer had just signed off on contracts, and there were issues that would arise. And oftentimes, this developer was in Bexar County, was in San Antonio, and oftentimes the venue was somewhere else in Texas. Or if it's not specified in the contract, then you go to the rules we just looked at in the Civil Practice Remedies Code, so that which really limits you. So if you agree contractually, then the courts will generally um, allow the parties to enforce that provision in the contract because that's what they've agreed to. And so, to give you an example, there's a development in Dallas, and the contract in this case had called specifically for venue to be in Dallas, and this individual was actually a doctor, and then was doing real estate development, not necessarily on the side, but was doing real estate development as a business. But this individual couldn't afford just to shut down the practice and go litigate a matter in Dallas. And you're talking about depositions, you're talking about hearings, you're talking about trial. And so this individual was not in a position just to be able to shut down the office and go handle these matters. He would have lost way too much money. And so in a lot of those instances, he just ended up having to settle. And it wasn't necessarily against him. It was against, or just let the matter go away. Because it wasn't necessarily against him where he was going to be sued. It was him trying to enforce an issue, but he would have had to do that in another jurisdiction. So that was one of the first things that student, he had talked to me after that. He said, I went in, one of the first things I did is from then on, we cleaned up the venue provisions on all those contracts to make it Bexar County. Because the question is, where do you want to litigate that? Do you want to litigate it in somebody else's backyard, or do you want to litigate it in your backyard? And so venue is extremely important, in my opinion. It's part of the strategy. It's a business strategy. And so that's one thing that you need to look at. That's one of the first things I say first things, but that's one of the main things I look for when I'm reviewing a contract is what is the venue specified in this contract. Okay. So extremely important. And so this is something that, if you're working on a contract, you need to consult with an attorney to make sure that, you've gone through the thought process. But this is one thing that I recommend looking at in all of your contracts is what is the venue provision. Statute of limitations requires that legal proceedings be commenced within a stated period. So statute of limitation requires a plaintiff to pursue claims in a diligent manner and to give the defendant time to prepare a defense on the merits of the claim. These statutes prevent prosecution of old claims, thereby reducing attempts to conduct proceedings for cases for which evidence has been lost, memories have faded, or witnesses have disappeared or died. So, for example, a state might require a plaintiff to file a lawsuit to enforce a real estate contract within 4 years. So let's go back to the Civil Practice Remedies Code here. I'm going to close up venue, and right below venue is limitations. And so these are our statute of limitations outlined in the state of Texas. So, for example, the 2-year limitations period is going to be for suit for trespass for injury to the estate or to the property of another, conversion of personal property. That's kind of like theft. It's like a civil theft. Taking or detaining the personal property of another, personal injury. So all car accidents must be filed in 2 years. So it's not uncommon for a personal injury attorney to wait until like the last day to file that lawsuit related to a personal injury claim. And so that's 2 years. A person must bring suit not later than 2 years after the date the cause of action accrues and an action for injury resulting in death. So a wrongful death claim. Here's 4-year statute of limitations period. So a person must bring suit on the following actions not later than 4 years after the date the cause of action accrues. So specific performance of a contract for the conveyance of real estate, penalty or damages on the penal clause of a bond to convey real estate, debt, fraud, breach of fiduciary duty. So there's a 4-year time period. We also get into some other matters. So here we have a limitations period for claims arising from certain offenses. So a person must bring suit for personal injury not later than 15 years after the date the cause of action accrues. So what that's what's called a statute of repose, and that places a cap where the statute of limitations says you must file lawsuit within. So for here, let's go back here. So here. The issue, like with medical malpractice or maybe even wrongful death cases, is trying to determine, or let's take a medical malpractice claim, that it may take the individual 6 years to find out that medical malpractice occurred, right? And so while there is a 2-year time frame on that, the individual must bring lawsuit within that time frame. From the date they knew or should have known. So it's like, well, the incident occurred 6 years ago, but the patient didn't find out that was the cause, or that surgery or operation or drug or whatever it may be was the cause. And so then that suit must be filed within 2 years from the date they knew or should have known. But then what the statute of repose does is it places a cap on filing lawsuits, so that you can't come back 20 years later and file a med mal lawsuit. We have the same thing for, like if you had you have a car that was built in the 1950s, and the steering pin goes out, 60 years later, or 70 years later, whatever. That trying to bring a products liability claim based on that that part has been used and overused, and so that allowing somebody to come in that many years later to try and file a product liability claim is just not going to happen. So we place caps on that, and that's called the statute of repose. So statute of limitation requires plaintiff to pursue claims in a diligent manner and to give the defendant time to repair. Statute prevent prosecution of old claims, and then we have the example here that we covered. So breach of contracts, 4 years. So now we're getting into ADR, or alternative dispute resolution. So the real estate industry has embraced alternative dispute resolution, or ADR. ADR is a method of resolving legal disputes without using the court system. So most often ADR occurs through mediation or arbitration. So those are the two types of ADR, mediation and arbitration. ADR often averts the delay and expense of litigation. Sometimes it does, sometimes it doesn't. Most real estate contracts require ADR before permitting the dispute to be tried in the court system. And then that's also a requirement in most courts these days, as it is. But it's not just ADR, it's specifically mediation. So we'll talk about that in just a minute. So for an example, real estate members affiliated with NAR must conduct themselves according to the NAR Code of Ethics. The code requires members to arbitrate disputes to the extent that the dispute arose from a real estate transaction. So additionally, many local real estate associations also require members to arbitrate disputes. So I'm gonna change that, and it may be arbitrate, but it also may be to mediate, and those are two different things, and that's what we're going to look at here in just a minute. Use of ADR offers several advantages. So resolution of the matter will occur much more quickly than with traditional court methods, and for the most part, that's true. And parties can choose professionals and specialists experienced in the subject matter of the litigation to resolve the dispute. Another advantage is that they are usually conducted in private, not in open court, and the parties can maintain the results of the proceeding in confidence. In contrast, anyone can enter a public courtroom and hear the evidence being presented, including information formally held as confidential by a party. So we'll look at the two forms of ADR, so mediation and arbitration. So mediation is an informal process. When we get to arbitration, that's going to be a formal process. So mediation is an informal process by which a neutral person, the mediator, assists the persons in reaching a voluntary negotiated resolution of a dispute. Mediator does not make factual findings or a final binding decision as a judge or jury would, or an arbitrator with arbitration. Instead, the mediation assists the parties to create, if possible, a settlement agreement amongst themselves. There's no set process, so they can come up with their own rules, or it's not uncommon for the mediator to have his or her own rules to facilitate that mediation. Sometimes the parties and their lawyers actively participate in discussions. Often the parties will bring experts with them to help explain their position to the other side. The fees of the mediator are usually equally split amongst the parties. And if the mediation is unsuccessful, the parties can still utilize the court system or arbitration to resolve their matter. And so it's not uncommon to have sometimes a pre-suit mediation clause in a contract, and then or to have a mediation clause in the contract. And then it's also not uncommon for courts now to require mediation by the parties before setting a trial date. And so the reasoning behind that is most cases get settled. Like the majority of cases get settled, not just the majority. I mean, a large majority of cases get settled. So those that actually go to trial are very few. And that's because of the time and the expense that's involved. And so mediation, usually the parties will agree to pick a mediator. Oftentimes that's the attorneys, because they've got familiarity with the mediators in their jurisdiction. You generally select a half day or a full day, and that's going to depend upon the circumstances. And so usually, like if it's a half day, it may be a total of like say $400 per party, so $800 for the mediator for a half day, and then for a full day, you could double that, or it could be let's say $1,200. So each party, they're splitting that $600 and $600. So it's going to depend upon the mediator in terms of what they charge. The mediation date will be set. Oftentimes the location is neutral. That way, one party or the other is not getting, a favorable, home court advantage by conducting it in one of the law offices of their attorneys. But that can happen. So usually a neutral location is selected. And then the mediator, based on how they're facilitating that, it's not uncommon for all the parties to meet in the same room, and then kind of lay out the groundwork, lay out the rules, and then they will keep one party in that room, and then put another party, or put the other party in another room, and then the mediator will go back and forth, discussing the issues. The one of the benefits of having the mediator has no. The mediator does not represent any of the parties, and then has no fiduciary duty to any of those parties. The mediator is there to try to help them settle the matter. And so, the parties sometimes get caught up on emotion, and their attorney may have tried to talk them into some common sense, but and they didn't listen. But the mediator can come in and say, look, your case is weak in this area, and if you went to trial on this, you're probably going to lose, or you're probably not going to get what you think you're going to get. So you need to come up with something reasonable as part of the settlement. And then the attorney will say, so what do you got? And then the mediator will say, what do you got? And the mediator will go into the other room and say, your case is not as strong as you think it is. And so he's not playing the parties off of each other. He or she is pointing out, the weakness in the client's argument or arguments, and trying to get them to come to a common goal of settling that matter. If the parties can agree, then they can write up the settlement agreement right there, or they can write it up later and then submit it to court. The parties can agree that the mediation is binding or that it's non-binding. If it's binding, whatever agreement they come up with then is submitted to the court, and they can't change it. Although I'll put an asterisk there, because we don't work in absolutes in the legal system. A lot of times, if it's non-binding, that means the parties attempt to go to mediation and resolve the matter, and if they don't, then they continue on with trial, and then they can let the court know that we attempted mediation and it was not successful. There are some limited instances where the parties may go to the court and say, Judge, we could go through mediation, And in this case, it's just not. It's going to be a waste of time and money. We just need to go ahead and set this for trial and get moving on it. The the one thing about mediation is if the parties do go to mediation, then they can start to show their hand in terms of what their strategy might be at trial. Although it's still limited in nature, but that's one con of mediation is that you're having to actually have these conversations and lay out your case to try and get to a settlement. But like I said, most cases end up getting settled one way or another before going to trial. Arbitration is a formal process, and arbitration is by agreement. So the parties have agreed to have one or more neutral third parties decide their dispute. So they could either have an arbitrator or they could have a panel of arbitrators, and usually that's going to be 3 arbitrators. Both sides present their evidence to the arbitrator. So what arbitration is, it's almost like a trial. It really is a trial. It's instead of going before the judge, you're going before an arbitrator or a panel of arbitrators. And so you have to prepare. You put on witnesses, you put on your evidence, and you can have binding arbitration or non-binding arbitration. And if it's binding, whatever the decision of the arbitrator is, that's the decision. If it's non-binding, the real con here, or the weakness of arbitration, is that you are presenting all your evidence, and then you're going to have to turn around and do that at trial. And so you get a pretty good idea of what your case looks like. In non-binding arbitration, unlike mediation, the arbitrator determines fault and liability. In mediation, the mediator just attempts to have the party resolve the matter. The one thing what I want you to do is go find one of your contracts you've signed, and let me put it a different way. Go read your cell phone contract, and look for the mandatory binding arbitration provision in that contract. There are some exceptions that come into play, that certain types of claims do not fall under that mandatory binding arbitration, but otherwise, by having a cell phone and having a cell phone service, you've agreed to mandatory binding arbitration with most of your claims against your service provider. If you buy a house from a builder, you will more likely than not have a mandatory binding arbitration claim in that contract with that builder. There are other contracts, very complex contracts between businesses, between large businesses, that will include mandatory binding arbitration provisions. And there's a couple of things related. The mediation, like I said, half-day mediation could cost the parties $400 each. With arbitration, it can get really expensive and really quickly. Just the cost associated with filing the arbitration can be in the tens of thousands of dollars, and then you're having to pay for your attorney's fees by your attorney's fees by per hour, getting ready for the arbitration, at the arbitration, and so that can get really expensive. Basically getting all your ducks in a row, just like you would for trial. And if it's mandatory binding arbitration, then that's the end of it. There's still some there are some instances where you can file an appeal to a judge based on that arbitrator's decision, but that's going to be confined to the agreement between the parties, the contractual agreement, and then also if the arbitrator committed fraud, or there's something else there outside of just hearing the decision and then rendering hearing the case and then rendering a decision. So so arbitration can get really expensive. There are some instances where the agreement is that the parties will split the arbitration filing fee and then cover their own attorney's fees. There are certain instances where the company says we will pay the arbitration fee, especially in smaller cases where an individual may not have $10,000 to file the arbitration, and you might find that more like in an employment dispute, with a company. So so arbitration has some benefits to it, but it's not the golden child, so to speak. I think mediation is necessary. I think it's beneficial in terms of trying to resolve disputes. Arbitration, there's a purpose behind it. There needs to be a strategy in terms of the utility of arbitration in your contracts. So if we look at case 1.2, Hall Street Associates LLC versus Mattel Inc., this is a 2008 U.S. Supreme Court case. The Hall Street case arose out of a real property dispute between a landlord, Hall Street, and its tenant, Mattel. The lease agreement provided that disputes were to be resolved by arbitration. The landlord claimed that Mattel had failed to prevent the contamination of well water on the landlord's property. After the dispute arose, the parties executed a contract providing for limited judicial review by a federal district court of the arbitrator's decision, both to ensure the award was based on substantive evidence and to prevent any contentions that the arbitrator made legal errors in making the award. These grounds for challenging an arbitrator's award were beyond those stated in a New York statute and the Federal Arbitration Act. So both of those come into play. So each state should have its own statute related to arbitration as well. Language of the court. We do not permit parties to agree by contract to expand judicial review beyond what was stated in the Federal Arbitration Act. Any other reading opens the door to the full-bore legal and evidentiary appeals that can render informal arbitration merely a prelude to a more cumbersome and time-consuming judicial review process and bring arbitration theory to grief in post-arbitration process. So the court said, if you're going to go to arbitration, unless the arbitrator, committed fraud or, there has to be specific reasons to appeal the arbitrator's decision. And even though the parties agreed in this instance for limited judicial review to ensure the award was based on substantive evidence, that's the purpose of the arbitration, is to look at that evidence, to look at the evidence and then make a decision. And in terms of any legal errors, that's all confined to the arbitration itself. And so the court said, we're not going to allow the parties to expand beyond that. If you want to do that, then just go ahead and go straight to court. But don't use the arbitration process as your base and then try to go to court to expand on that. The decision, the grounds stated in the Federal Arbitration Act were the exclusive grounds for determining whether an arbitration award may be vacated or modified. So that's where you've got to go to the Federal Act and then look at that list of the reasons for a specific appeal. The one thing to note that if the parties, like if a contract has a mandatory binding arbitration clause, or just a mandatory arbitration clause, and then one of the parties were to file a lawsuit, then generally what's going to happen is the other party would file a motion to stay that litigation, basically to stop it, and then say, Judge, we agreed contractually to arbitration. Let us go do our arbitration. And then if the parties come back, after arbitration is completed, the parties come back and then submit that arbitration award to the court, and then the matter is resolved that way. So generally you have some type of litigation usually associated with arbitration, but then not always. Okay, so it just depends on that process. But then on other instances, the court may just dismiss that lawsuit altogether. Okay, so if the parties want to ensure their arbitration, so focus on ethics. If the parties want to ensure that their arbitration proceeding is fairly administered by allowing for limited judicial review, why shouldn't they be able to knowingly agree to do so? So think about that. Give that some thought, because the courts here said, any other reading, we do not permit parties to agree by contract to expanded judicial review beyond what was stated in the FAA. Any other reading opens the door to full-bore legal and evidentiary appeals they can render informal arbitration merely a prelude to more cumbersome and time-consuming judicial review process. So what that means is that then anybody going through arbitration could then appeal those matters to the district court, and that's not the purpose of arbitration. So I think the argument there is, if you want to do that, if you want to have that option, then go to court, go to trial. Don't put a mandatory or don't put an arbitration provision in your contract. Go to trial, and then if you don't like the decision of the trial court judge, then you appeal it to the intermediate appellate court. So here's a scenario. The sellers, coming back to this scenario, the sellers entered into a written contract with the buyers for the sale of property in Utah. The contract includes the following provision: dispute resolution. This contract will be constructed under Utah law. Okay, so that's what we call the choice of law. So we're applying Utah law, not federal law, not some other state law, but Utah law. All controversies arising out of this transaction or this contract will be settled by binding arbitration in the county where the property is located. So one, we have binding arbitration provision, and then two, we have a venue provision in terms of where that arbitration will be heard. The arbitrator may not award any remedy not provided for in this contract. So that's an important thing. When you look at a contract, you want to look to see what constitutes default, and then what are the remedies in the event of a default. So in this case, the arbitrator may not award any remedy not provided for in this contract. So let's say that the contract does not include a provision for attorney's fees. Okay, so then if that's the case, then the arbitrator may not award attorney's fees as part of the decision associated with your arbitration. Okay, so you've got to make sure you've got certain provisions in your contracts. So in this case, that's extremely important. So what are the remedies? After closing, buyer was concerned the property included protected wetlands associated with the Great Salt Lake and could not use the property for the intended purposes. Buyer filed a lawsuit in Utah State Court. The trial court dismissed the suit because of the arbitration provision. Buyer states that he should be able to litigate in state court. So the question: should the buyer be compelled to resolve this action in an arbitration proceeding, or may they proceed in state court? So problems. Chapter 1, problems and assignments. So question 1. For each of the following items, classify the property as either real or personal and as either tangible or intangible. So take a screenshot of this and make sure you classify these as single family. As either real or personal, or tangible or intangible. So single family home, sofa, air conditioning unit, mobile home, a solar easement between neighbors, gas deposits, and oil deposits. Question 2. Rank in order of priority the following sources of real estate law. So state statutes, treaties, state constitutions, federal statutes. And then if you added in the U.S. Constitution in there, if you added in federal regulations, where do all of those fall? Question 3. Vivian owns a residential property and has become delinquent in paying her real property taxes and her mortgage. The mortgage lender files a lawsuit to foreclose on her property, and the lender is required to pay in full the local government's property tax amount because the state Supreme Court in Vivian's jurisdiction has held that property taxes take precedence over all other types of liens, such as the mortgage lender's lien. And that applies in Texas too. The ad valorem tax lien is a superior lien to any mortgage liens. When the state court follows the Supreme Court's ruling, it did so by applying what doctrine? So what's the name of the doctrine that we covered? Question 4. Bob is a resident of New York. However, he also owns beachfront property in Florida. He has grown old and wishes to sell the Florida property since he can no longer make the trip down to use it. He sells the property to his friend Gary, who has moved to Florida to escape the harsh Texas summers. Bob knew the property's roof leaked excessively when it rained and that Gary would be unable to realize this during an inspection of the property. Months later, during Hurricane Dorian, Gary's home was severely damaged due to the leaky roof. Gary wants to sue Bob for $80,000, but he is unsure where he could file his claim. Advise Gary on all possible jurisdictions in which Bob can be sued and explain why each jurisdiction is proper. Question 5. Construction R Us builds a commercial property and is owed $70,000 after completion of the project. It seeks to file a lawsuit to obtain payment for the balance due and owing. The company's construction colleagues have noted that civil cases, due to a backlog in hearing civil cases, take approximately 4 to 5 years to get to trial. Construction R Us wants to file its lawsuit in federal court. Can Construction R Us file its lawsuit in federal court? Question 6. Jenny had a neighbor who trespassed onto her property. The state required her to file a lawsuit within 3 years. Jenny was on vacation when the 3 years expired, and immediately upon her return, she filed a lawsuit for trespassing. Her lawsuit was filed at 3 years and 4 days. What defense will her neighbor use to prevent Jenny proceeding with the lawsuit? Question 7. Identify and explain the key distinctions between mediation and arbitration. Question 8. Calvin has a lawsuit that he won at the trial court level. He lost at the appeals level. However, that ruling was confirmed by the state Supreme Court. Okay, so he won at the trial court, lost at the appellate court, lost at the Supreme Court. Calvin believes that the state Supreme Court has not correctly applied the law and wants to go to the U.S. Supreme Court. What must Calvin do to have his case heard by the U.S. Supreme Court? Must the U.S. Supreme Court hear Calvin's lawsuit? Question 9. Research your state law to determine the applicable statute of limitations for the following. Breach of a written contract. So look in Chapter 16 of the Texas Civil Practices and Remedies Code. And there are the references. So that concludes Chapter 1, Introduction to Real Estate Law.